topic topic about the roadmap for the patent protections. So if you have arise in your mind a well and good idea and how to protect your idea and how to get a new idea, these all the things I consider for these presentations. So now enter into the topics. So the outline of the sessions is the what is the difference between the idea, innovation, and inventions, and then patentable criteria and patent specification structures, patent filing procedures in India, and forms and fee structure, and finally concluding the summary. So I hope at the end of the sessions you understand the term idea, innovation, and inventions, and understand the patentable criteria, respective forms, fees, and the filing procedures. Before we enter into the topics, we just know about our strength of our Indians. Because knowledge revolutions are arised in the 21st centuries. So nowadays we focus on only the intellectual properties. So everything in mind. So your thinking will give you one technology solutions or technology designs. These all the things belongs to the knowledge. So 21st centuries arise the knowledge revolution. Before the previous centuries, in 17th centuries, arise the scientific revolutions. 18th century arise the political revolutions. 19th century arise the industrial revolution, and the 20th century arise the information revolutions. And now we are in 21st century, especially knowledge revolution means is the product, marketable products, patent. These are the things comes under to the knowledge revolutions. Why I'm saying this? India is the hub of knowledge because a lot of the Rig Veda is also lot of years before we found this. And then Susruta is the first plastic surgeon. They treatments, they find out the treatments that help to deal with some of the related issues, eyes, dentals, flesh replacement, knee rectification, and then plastic surgeries. So now the technology, without any technology support, they do some things. So in this way, India is the hub of the knowledge. And then another one is the WIPO. WIPO is the World Intellectual Property Organizations. These organizations announced the all over the world, 190 or 120 countries are participated a ranking based on the ranking involving in our Asian region. In India, focusing the further the consistent performance in the last 5 years. And then this is the economic regions announced by the WIPO. And then I directly now enter into the topics, because first you get an idea, then move on to the invention. Invention, what is the invention means? That is the new thing one. Thomas Alva Edison invented a bulb. That is the new one. Innovation means something to do, improve the performance or cost wise or technical improvement. These are the innovations. The flow of innovation means first create the ideas and then move on to the invention. It must be in a new thing. No one find out in the anywhere in the world, and then move on to the innovations. Fresh ideas directly deals with innovations is the wrong route. Innovations is the Steve Jobs is a innovator. So innovator means doing some things in the existing products and improve the performance or technical performance, maybe economic levels. These are the deals with the innovation. Invention means completely new, that items no one find out in anywhere. Where you get this idea? So one is the best is way is the student community, and another one is the problems in the society or industries. So the lot of problems are available in the societies nowadays, and also as well as in the industries. If you guess anything, it's a train. So in this train have some patentable innovations. That is the claiming an upper berth in a train. Normally it's difficult to person reach to the upper berth. If you reach upper berth means some of the persons are different, your leg is disturbed to sitting persons, that person is feel irritating ones. So this is the climbing technique. So with the footpath also supported, and then climbing for the hand. So your body weights also balanced through this upper climb. This idea is created by the IIT Kharagpur students. That is the this one is the patentable one. And then this is the industries. So industries require the surveillance monitoring. So you fix here some innovations is created, so through the monitoring process. And then here nowadays it's highly difficult to uh, bus traveling routes is peoples are difficult to identify where this bus is good. So they provide the solutions through the LED displays. So the red color is the give the more wavelength compared to the this kind of the board's black color. So suddenly you reach the uh, suppose older people also identify this bus go to this way or this destinations is easily understood. And then another one is the now famous one is the cricket. So cricket is one of the best solution is provided. That one is also the patentable idea. That is the LED cricket stumps. So this is one is the patentable idea one. Now, what is patent? So the patent is exclusive grant. That grant provided by only government of India for who invented a new idea. For that people provide the grant. Why? Because for protect the ideas from the others. Nowadays, if I invented one product means I discuss with some other friends. So my friends also maybe copied that one and sales. So my intellectual property at the time will lost. I face the law losing the amounts. So at that time, if I patented, my friend is copied. I filing a case against him, get the for the money. And how long? It's certain limited periods. What happened after limited periods? So after limited periods, the documents provided to the public domains. So anyone take it and use it. So the patent rights is the monopoly rights. It's a validity for up to 20 years. No one, if you filed a patent, if anyone is a copied at that time, your idea will be protected through the patent documents, and no one copying or making, selling, importing, these all the things are completely protected. If anyone doing that kind of activities, if you file a case and get the uh, amount for the usages. Why patents? So patent is the exclusive rights. So you have a right on, and then opportunity to sell or license the invention. Yeah, here the corona injection also invented in a foreign country. So India get the license. We have the licenses have some dealing with why we invented a product nowadays. So generate the revenue, sorry, earn the money. So you give the license means so profit ratios based you give to the your patent, and then it's one of the way of generate the revenue. And then you build a, if yes, and the COVID-19 injection is the it's helpful to the nations and all the peoples worldwide. So that gives the one positive images for the particular pharma industries. What can be patented? It's the process or method. So maybe the chemical composition methods and subjected to the some criterias. And then composition of matters and product or device or apparatus. These are the things are to be patented. And then check the patentable criteria. So the patentable criteria first is the novelty, another one is the inventive step and industrial applicability. First, novelty or invention. So the novelty means it's a new thing in no one find this product anywhere in the world. It should be in new. That is the novelty. And or check the databases, patent databases. So no one or journal databases, no one published anywhere. These all the things are cross verified before you going a filing. Then you move on to the file. And then some of the inventions are not patentable. Then one is the if against the natural law means is a not patentable one. And then if anything injurious to the public health, these all the things are not patentable. And then scientific principles or formulations of abstract theories also are not patentable. And some of the substance mere admixture, this substance I mixed combination get a new mixture, that is not a patentable. And another one is the mere arrangement or rearrangement. It means this device is there here and one more device is here. So I changing means at the time improve the performance means that is the mere arrangement. This case also belongs to the not patentable. And then method of agricultures or horticultures, not patentable one. And main thing is the process of treatment of human beings or animals. These are not patentable. And then mathematical or business methods. You are a computer science department, so computer program especially not patentable one. And then any inventions or anything related to the atomic energy or defense, these all the things are belongs to the not patentable. Because the atomic energy and the defense rates means it's give you a patent means it's create the terrorisms all over the world. So then this aspects the Indian Patent Act banned this kind of related inventions. And then inventive steps. So the inventive steps means your inventive steps should improve either technological improvements compared to the existing one or economic significance. So the cost wise will be reduced. Another one is the technical performance will be improved or both mixing. So technical advancement or economic improvement. Here is the one opener. This opener, I think I am 3 years to 5 years baby at the time. I think 1994 or 1995, they followed this kind of the milk powder box. Its open is the highly difficult. That difficult to overcome through this opener. So this opener user for the left-handers and also rotatable one. So this is the example of the inventive steps. And then industrial applicability. So industrial applicability means so usage to the industries or publics. These are all the things related to the industrial applications. I am interested to file a patent. Where to find this is patentable or not? You search the patent database. The patent database classified into two types. One is the free database and another one is the paid database. I listed out here some of the free websites. One is the Google Patents, and then IP India, BIPO, and eSpaceNet, and ESP Tipo. So these are the free websites. You search based on this kind of the idea keywords. You get and search your idea similar to anyone previously published or previously get a patent. You cross verify through this kind of websites, and then now move on to the patent specifications. So the patent specification divided into two types. One is the provisional specification and the other one is complete specification. The structure of provisional specifications are title. So your title should be within 15 words, don't exceed or beyond the 15 words. And then field of invention. And the field of invention means which area your invention related to. For example, solar energy or artificial intelligence or Internet of Things. These are all the mentioning the field of the invention. And then background out. So the background out you take is the basic informations and some of the patent literatures they should be added in the background art. And then summary of invention based on your idea inventive steps you put in a summary of the inventions. In provisional specification, no need diagrams, claims. If suppose you feel necessary to add the specification means you add it. So provisional specification consists of the main four things. One is the title, field of invention, background out, summary of the invention. And then complete specification. So the complete specification, the title as it is within 15 words, the field of invention related to the which area, so solar energy, artificial intelligence, Internet of Things, and then background art, including citation of prior art. So prior art search means the simply like the literature survey, those previously published or existing the pattern idea level. These are the things included in the background arts. And then objects of invention. The objects of the invention means what are the inventions based on your idea. That is the inventive process should be listed. And then summary of invention, and then illustration and drawing. So the drawing should be drawing the A4 sheet. So here based on some rules is there, corner and left corner, these are the things. So diagram mentions in the numerals or alphabets formats, and then based on the diagrams you give the detailed description. This is the next part one. And then claims also start in part of the patents, because in the LED cricket stump bells is rated as the strong claims. So without if you give any loop in the claim means other person will be easily copied your idea and improved your intellectual property completely damaged. That means your money revenue generation process is completely damaged, or you lost everything. You give an idea for another one person, that person may improve your idea based and then get a patent, more chances. And then claim must be 3 claims at least, maximum 10 claims. So beyond the 10 claim means you need to pay additional amounts. And then what are the forms? The form 1 is the basic application form. That application form is the consist of the divisional application, PCT application, national phase application, ordinary applications, and then addresses and who are inventor, corresponding address, and then these are some of the conditions. These all the things are in the form 1, and also how many pages your patent applications, anything drawings, claims, these all the things are crispy matters collected in the form 1. And those who are inventor of this idea, bottom of the form should be shined. And then form 2 deals with the provisional or complete specification. Form 3 deals with the statement and the undertaking. So the undertaking is this kind of inventors, the persons are take this idea. This deals with the form 3. And then form 5 only in case of Indian application only. I take as the declaration of inventorships. These persons are inventor in this invention or in this idea. These are the listed out in get the signature of the inventors in form declaration 5. And then form 18 is the request for examination. Here I filing a patent today. At the time I may be I interest, I request for examination. If I'm uninterested means within 48 months, if I have no money, so money shortage, so later stage, so 48 months, within 48 months, I need to request for examination. Else, my application will be abandoned. And then form 9, a request for yearly publications. So if I filed today means 18 months after 18 months published in the patent database. Else, I 18 months I'm not waiting for publishing means interest to additional pay for the yearly publication. So yearly publication means within 1 month. Today I am date is the today I am filing. Next month as on date July 17th. Within July 17th, my applications and details everything published in the Indian patent journals. Else automatically after 18 months published in the patent journal. If through filing a patent through the patent attorney or a patent agent, or if or any I think assignee means included the form 26, get the signature from the patent attorney. And then forms and corresponding fee structures. The form 1 is the natural persons. So we are the academician or students. I concentrated. Small entity and other small entity means is the medium scale industry and a large scale industry. So the application form 1 is 1,600 rupees. In provisional applications, form 2 no fee, but if you exceed the 30 pages means each page is 160 rupees. Climb up to 10, maximum 10 climbs is allowed. Beyond the 10 climb means per climb 320 rupees additionally pay. And form 3 statement undertaking, no fee. Form 4 is the extension of time. The extension of time you need to pay 480 rupees. And then form 5 no fee. If suppose change in the applicant, you feel means at the time you pay additional. If I am first inventor, my friend is the second inventor, and another one friend is the third inventor. In between is we have created on fight means at the time is I remove one person means, so other time you change the applicant means I need to pay 800 rupees. And then the notice of pre-grant opposition, no fee. Notice of post-grant opposition, 2,400 rupees need to pay. So the post-grant opposition means if any one person interested opposing the points, this already existing one, this is copied one. If I eliminated my friend is understood, he'll remove the name from my idea. So the person post grant opposition beating me. So based on the questions of the examiners, these are the things are faced. And then form 9 yearly publication 2,500 rupees, and request for examination form 18 4,000 rupees, and the foreign applications permissions I think is 3,000. This is the process of the patent application filing. First you file application. First you interest focus on protect your idea based on the priority date means you file a provisional specification. Some after check the patentability criteria, filing a provisional patent. So idea will be protected on you. Today I'm filing provisional patent June 17th. I filing. Tomorrow June 18th. Another one person is filing a same concept, same idea similarly. So at the time my idea is protected. That person filed a complete specification. On 18th, I filed a provisional specification 17th. So priority date will be given to me. So at the time I protected my idea through the legally. If I file a patent today, June 17, complete specification within 12 months I file. Else, my application will be abandoned. Suppose I file a complete specification within 12 months and then move on to the, at the same time, at the time of the complete specification filing, I request for examination or request for a yearly publication. These all the things are there. And then complete specification directly. And today filing a complete specification means after 18 months automatically published in the patent journal, or I request for a yearly publications. Next month, July 18th, will be published in the patent journal. And then if in between anyone is the opposition, suppose I removed my friend name, that person may be opposing after filing a complete specification within 6 months. If suppose my friend exceed the 6 month means they suppose my friend know about this kind of the opposition means maybe a forgotten means they will lost the pre-grant opposition chances. And then within 40 minutes request for examinations. If suppose I am unable to request for examination means my application will be abandoned. After filing request for examination, the examiner will evaluate the my applications based on the what are the details given and explanations based on the things. First examination reports sent to the respective patent applicants. So viewed the response, what are the data, what are the queries, these are the things get. If any objection may be arise by the examiner, if suppose I know the logic means I reply the form, this is the logic. If examiner so response to the examiner, so at the time the answer the examiner will understood and valid one, so move on the further. If suppose your objection point, examiner objection point is the more doubtful one, means at the time controller decision is a major role. At the time controller call you for a hearing, so through the court, so the high court is deal with that kind of activities. In one more case, the Bajaj and Apache filing a patents. Apache asked, "This is the my idea." Bajaj asked, "This is the my idea." So war between the TVS and Bajaj. So the finally finally and legally owned by the Bajaj, because they have legally filed and the priority dates. These all the things are supported to Bajaj. Then only the finally after hearing between the TVS and Bajaj, the court give the order to the suitable for Bajaj only. So at the time the TVS will leave. And then if any within 6 months you proved anything, and then after proving is over satisfied means, and then move on to the grant. So after your grant means, so grant publication is there, the Indian patent database. So grant publication will be published. Okay, next IP office in India. The patent office. We focus on the patent. So for patent, Kolkata is the head office one, and then regional office is the Delhi, Chennai, and Mumbai. What are the other states? If I think Andhra Pradesh means you nearer to Chennai. So Karnataka, Kerala, Telangana, Andhra Pradesh are nearer to Odisha. These are the thing. Nearest regional office is the Chennai. So the filing the patents through online and offline mode. Offline modes is you take a DD to the respective regional office and send to the post. And then some of the other intellectual properties of the designing is the Kolkata trademark registry is the Mumbai is the head office. So Delhi, Kolkata, Chennai, and Ahmedabad, and geographical indication registry Chennai. So on copyrights is the Delhi is the headquarters. So these are the IP office available in our India. And then protection. Why we protect, or what are the ways we protect? If you approach a patent agents or anything research institutions, or nowadays a lot of available agents, patent agents, or all the things. NDA is the non-disclosure agreement. Non-disclosure agreement will protect your ideas and safeguard. And then in this way you protect legally means some other person copied, theft to your idea. These all the things are avoided by only the protection way. The best example is the fight between the Bajaj and the TVS. They legally file through the everything. Then only the court give the judgment to the Bajaj. And then if suppose maybe your research related patent means is the research collaborative agreements. These are the things, some of the agreements will help protect your idea copied from other persons. Yeah, why I'm saying the protection means, it's already the told the previous slides. This cricket stump is a patent good, well and good, right? The claims. So the claim is the heart of the patents. The claims, no loop is there. A lot of persons, because nowadays the cricket is the commercially one. So the IPL, Premier Leagues, lot of the tournaments are nowadays conducted and conducting. So it's one of the revenues. So it's highly difficult earlier while reach the batsman or stumping. It's out or not out. It's highly difficult. Now the blinking means you take a decision soon and clear cut. The decision make over easy, and also it created the revenue. This is the bail cost in a Indian Premier League cost the 30 lakhs. These are the leagues in Australia. Big Bash league is the $40,000. In Pakistan, conducted a PSL for 47.5 lakhs. In England, T20 Blast 23472. So the amount is one of the league. It's a worldwide cricket is the popular. So it's a revenue is generated at same time. No one copied. That is the beauty of this pattern. And then Bangladesh BPL. Here the currency the Taka. So 2450674. So this amount, this kind of the amount is the easily generated by intellectual property only. And then in our India, this is the Bandicoot is developed through the Kerala startup missions. This is the final year students. After complete the final year, went to the companies. After 6 months or 1 year, again the final year project students talking discussions, and at the time Kerala government also announced the Kerala startup mission. The person again retakes, do the project and establish, and the finally made the sewage cleaning. It's nowadays is no equipment clean to the sewage. Is a man only cleaning the sewage. At the time, lot of men will be died because of poisonous gas is generated at that affect the human clean person. So this is the helpful to cleaning the based on the robotic methods. First filing the Indian patents, and now we are more than 20 countries filing the international patents. Is the successful startup also. And then how can you contribute means if nowadays Australia patent, South Africa patent, these all the things within 1 month get a grant. It is not worth. It's like a fast food means instant patent granted is there in the Australian. That is now no use for others. They use some other person get generate the revenue. Some of the academician also lose the money. So you contribute your own way. That is the mainly don't buy fake. That is the innovation, Australian innovation grant and African innovation grant. These all the things are by fake one. And then be innovative through the technology solutions. And then think outside the box. Don't within the one. You think beyond the levels using the technology solve the problems, and then produce original work. Be ethical. You don't copy it from any other. You take it as reference in the existing one. That's well and good. But as it is, don't copy it. That is the produce original work in the ethical way. And then in India, WIPO take a survey about the innovation ranking. India up to 2010, we give a somewhat consistent performance. After 2011, we faced the dismissal performance 22nd, and then 64 and 66, and then 76, and then 81 in 2015. And then after 2016, we consistently, our India focus on the consistent performance, like its major contribution from the student community, research communities, and other industries. These all the things are to improve our nation. So 2016, so suddenly jump into the 15th position, and then 60, 57. So now finally we are in the 46th position. So in 2015, 81st position globally, now 46th position. So IAM means intellectual properties, IP innovations. These all the things are contribute to our nation also. So some of the IITs only filing this patents. So other organizations and other institution students also show interest to file a patent, think a good quality and idea. And then finally, concluding the session. So the patent is the exclusive rights that prevent the any person copied or sale. These all the things. If any person copied, so be legally by the court. Before you filing a patent, you check the patentable criteria. So the patentable criteria, 3 patentable criteria. One is the novelty. So check no one published or no one product in anywhere. And then technical advancements, I mean technical performance or economic levels will increase means. And then applicability, so the application of usage. And then after this all the things over, next you move on to the component of specification. Specification is the 2, provisional or complete. If you prefer a provisional means within 12 months you file a complete specification, else your application will be abandoned. And then move on to the complete specification. So the complete specification filed at the same time, request for examination, or within 14 months request for examination, else your application will be abandoned. And then from the within 6 months, if anyone pre-grant opposition filing, at the time you reply corresponding queries answer. Or post grant opposition, suppose granted means after 6 months filing a maybe grant opposition. Before grant means controller have any hearing, so your logics say any doubtful one when objection is more over means you prove it through the hardware in front of controller and coach, and the proved, and then you file. So form 1, form 5, form 9, these are the major forms. Form 2, provisional and complete specification, these are them. And then undertaking form 3. And then these forms and procedures protect your innovative idea or inventive idea. Okay, and finally thanks the department of CIT for giving this golden opportunity for presenting or create the awareness about the roadmap for patent production, especially for the students and faculties. Thank you.
So participants, if you have any doubts, you can raise your hand so that I can unmute you. And you can ask your questions. Feedback form is posted in the chat box. You can please fill it.